thanks, Ben Burns, for coming to join us today and talk about what happens when you go to court. So, first question, what sort of situations end up in people going to court?
There's loads of situations you can end up going to court. The one that people tend to be most familiar with from the TV and films and stuff is if you're arrested for a crime, you need to go to court to defend yourself. Also, if you're a witness to a crime, you can get called to court or summoned to court to give your evidence. Then there's this whole area of law that isn't criminal law, which is called civil law. And that could be anything like going to court for a divorce or a childcare issue in the family court. It could be that you're suing a company or a person, or you're being sued by a company or another person, and you need to go to court in relation to that. There's all sorts of things, negligence, like if, for example, you think a hospital was negligent in how it treated your relative, you could go to court for that. And then you could go to court because of a dispute with your employer, a divorce. There's many, many reasons you might end up going to court.
I'm no stranger to a courtroom drama, but what would you say are the biggest misconceptions between the world of TV and the real world?
Gavels.
We love a gavel. We
don't get gavels in the courts of England and Wales. People tend to watch kind of TV dramas where something very eventful happens. A lot of the time, court hearings just aren't eventful in the sense that there's this dramatic kind of jaw-dropping moment. It tends to be a lot of procedure, a lot of explaining what the law is, how it applies to the case. So I'd say the biggest misconception is that it's going to be like what it is on TV, and it very rarely is.
If a person has been summoned to court, what kind of help or assistance is provided to them to get ready to go to court?
I mean, if you're going to court because you've been arrested for a crime, then you have the right to access a solicitor for free, and that you might have your own solicitor already, but if you don't, there are these things called duty solicitors, and they have to be available 24 hours a day, 7 days a week to help people who've been arrested for a crime. They'll explain what your rights are in the police station, what will happen in the police station, and then when you end up going to court, they will kind of explain what's going to happen and what you need to be prepared for. If you've been summoned to court as a witness, there is something called the Citizens Advice Witness Service, and they provide kind of practical support to people who are going to court as a witness. It could be just explaining how the courts work. It could be doing like a pre-visit to court. So if you're nervous about the court hearing and giving your evidence, the witness service can actually take you to court to kind of look around. And they can provide kind of moral, emotional support as well as a few other things.
And so these things that we're talking about, like the witness, what did you call it, sorry?
The witness service.
The witness service and the duty solicitor, do you find them at the court itself?
Duty solicitors work in police stations. The witness service is run by Citizens Advice, but they cover every court in England and Wales. There are also organisations like Support Through Court. So increasingly, especially in areas of civil law, people represent themselves in court, and there are charities like Support Through Court, which, kind of does what it says on the tin. It supports people who are going to court to represent themselves by explaining how it's going to work, giving them advice, and in some cases arranging for them to get free representation.
And do I have to use a solicitor if I go to court?
There are a few options actually if you're going to court. So you could either use a solicitor or a barrister to represent you in court. So they're just two different types of lawyer. And there's another type of lawyer called a chartered legal executive, and some chartered legal executives are allowed to represent people in less serious court cases. Increasingly, people represent themselves in court, so they don't have a lawyer to represent them. Sometimes that's through choice, but more often than not, people represent themselves because they can't afford a lawyer and they can't access public money from the government, which is called legal aid, and that's because it's been cut significantly over the last decade or so. So a lot of people do have to represent themselves, especially in civil cases.
I've also heard of something called a Mackenzie friend. Could you tell me what that is?
I was a Mackenzie friend about 8 or 9 years ago for something called the National Centre for Domestic Violence, and my role, after I got a bit of training, my role was to provide, I guess, moral and practical support, explain how the court process would work, and answer any questions about, how will the judge speak to me, what will happen if my ex is there, and things like that. Helping prepare paperwork for court, and meeting them before the court hearing and then going into the court hearing just as a kind of bit of moral support, so just to have someone there with them. But it's really important to understand that Mackenzie Friends aren't lawyers. They can't do the things that lawyers could do. So they can't sign documents on your behalf, they can't give you legal advice, they can't represent you in court, so they can't say things on your behalf to the judge and things like that. They're really there for kind of practical and moral support rather than like legal support.
In terms of legal advisors, if you're in court and you've got a legal advisor, how can you make sure that that relationship is useful?
I'd say a big tip is to make sure you have realistic expectations about what your lawyer is going to do for you, what they're allowed to do for you and what they're not allowed to do for you, but also what expectations you need to meet as your lawyer's client. So really, your lawyer should be explaining really clearly at the start of your case, this is what I'm going to do for you, this is when I'm going to do it by, and this is what you need to do for me. And that might be things like helping get evidence and provide evidence and stuff like that. So if you have any questions or concerns about what the expectations are, you should ask those questions and raise those concerns, just so that you're not kind of thinking, well, my lawyer should have done this for me and they failed. Because it might be that your lawyer isn't actually allowed to do that thing for you, or that they couldn't do it because of something that was going on outside of their control. You know, courts can sometimes be slow. And that's obviously frustrating, but it might be that it's something your lawyer just couldn't control. So that's one thing. Another thing I say is be really open and honest with your lawyer. So especially in like sensitive or traumatic or difficult cases, people can, your lawyer will need to ask you, potentially upsetting, personal, sensitive questions, and that can obviously be really hard to deal with. You might be kind of having to relive a traumatic event or something like that. But it's really important to remember that your lawyer has a duty to act in your best interests. So when they ask you these questions, they're hopefully doing it because they're trying to get information out of you that will help them present your case in the strongest way. So be open and honest with them, and just remember that they have a duty of confidentiality as well. So if you share something with your lawyer that's really personal, really sensitive, because they need it to understand your case or to progress your case, they can't share that information without your kind of full consent. So sometimes people do have worries that their lawyer is going to kind of go telling people all their private life. But it is really important that you're open and honest with them. Let your lawyer know if you have any specific needs or concerns. So that could be from like a health condition, it could be from a disability, it could be certain caring responsibilities, certain days or times of the week where you do kind of religious observance and things like that. And if you just let your lawyer know about these things, they can kind of adapt things like the times they meet you, where they meet you, the timescales they expect you to respond to them, and they can also help arrange for kind of certain measures in the court when you actually get to court to help you kind of participate in the hearing or the trial. So it could be like a physical adjustment to the courtroom, or it could be arranging for some kind of extra support to help you understand what's going on. So
actually it can be quite flexible in the courts to help people take part.
Yeah, there's lots of things they can do, and they have a duty to help people participate effectively in proceedings, and that applies to everyone, but particularly people who might be kind of at risk, or especially at risk of not being able to participate, and that could be because they're not fluent in English, it could be because of a disability or health condition. There's loads of things they can do, from like changing the layout of the courtroom to kind of communication aids and things like that.
So like translators?
Yeah, things like that, and even just making sure that you get the breaks that you need, and that could be from like fatigue, it could be from physical pain, it could be from just being emotionally overwhelmed by what's going on in your case. So I would encourage people to have that conversation early with their lawyer, because their lawyer's there to help them. So their lawyer can kind of make sure that the court is kind of up to speed on the things that need to happen to help you take part in your case.
And presumably those kind of adjustments are available for both defendants and for witnesses and anybody else who might be using the courts?
Yeah, and in the case of witnesses, the witness service again can help there, because obviously a witness won't have a lawyer in the same way a defendant will, so they can use things like the witness service and support through court.
So this already, to me, sounds like quite a daunting day out. Mm-hmm. Could you maybe explain, so I've got off the bus, what is my day through the courts going to look like? Have you got any kind of idea about typical things that I might have to do?
get an early bus, get to the court early. So if I was going to court, I'd get there probably an hour early, or maybe go for a coffee even before that, just so that I wasn't freaked out that I was going to be late. Meet your lawyer as well before the hearing starts, and any other, if you haven't got a lawyer, meet your Mackenzie friend or whoever else is there to support you before, just so that you can settle in. You go through kind of security when you get to court. It's a bit like a slightly weaker version of airport security, I guess, where you go through one of those scanners and put your things in a tray. You can do a pre-visit to court as well. So, like I said, support through court. They will often take witnesses for pre-visits to court if they're nervous about going, and that's an option for anyone who's going to court, is to kind of visit ahead of time just to see what it's like.
And what happens if the worst happens and you either miss your court date or you get there late?
If you miss your court date, it can get a bit tricky and a bit technical depending on the area of law, exactly what can happen. But some of the things that can happen is that the case gets decided in your absence, which you really don't want to happen, because you haven't had a chance to put your case forward, to explain why you should win your claim or why the claim against you shouldn't win.
So what should my solicitor be doing when they're representing me in court, or I suppose any legal advisor?
A lot of the work they need to do it properly happens before you get to court. So they need to be really prepared. They need to understand your case, what instructions you've given them. So any lawyer who's representing you in court has a duty to follow your instructions, and that just means what you've told them is your case, basically. And they absolutely cannot kind of make up their own instructions and kind of do things that you haven't given them permission to do. So they need to make sure they're following your instructions, make sure they're prepared, and not just prepared in terms of the law and the facts of your case, but prepared in terms of you and what your needs are when you're in the courtroom. So do you need any extra help so that you can participate in the court hearing? So that could be if you need breaks, or if you're showing signs during the court hearing that you're not keeping up, or that you're kind of really distressed or something, then your lawyer should really be aware of those things so that they can step in and help you if they need to, particularly if you're giving evidence. If you're kind of glazed over or upset because when you're being questioned, or your lawyer spots that you're just not understanding things, they should really step in to make sure that you're able to take part.
And how do I know if my legal advisor is doing a good job during my hearing?
It can be a bit tricky, because I compare it to if I was watching a car mechanic do their job, unless the car exploded or the car came out looking amazing, I wouldn't know if the mechanic had done a good or a bad job. And it can be the same with a lawyer in court. It's a technical skill. The law is complicated. The way they have to talk to the judge isn't how they would talk to kind of how I'm talking to you now, or how we talk to friends and stuff like that. So it can be tricky for a normal person, so to speak, to know if their lawyer's doing a good job, unless, like I said, the car blows up. So if they start getting shouted at by the judge because they're terrible, then you can tell they're doing a bad job. And if the judge is very quickly, excellent argument, Mr. Smith, who's a lawyer, then there are signs from the judge that you can kind of pick up on that your lawyer's doing a good job or a bad job. Other things to look out for, you will have agreed before court what your instructions are, so what you've told your lawyer is about your case and what they're allowed to say and what they're not allowed to say. So if you should make sure they're following your instructions. That's a big part of it. Do they seem well prepared? When the judge is asking them a question, or whether they're having to say something to the judge, are they just seeming really disorganized and they don't know what is going on? That's definitely a sign that they're not doing a good job. You'd expect them to be fully prepared and on top of things. I would just caveat that by saying that they're human beings. They're not, they might have to look something up in their case files or something to remind them of a particular date or time of an event.
I've heard of magistrates' courts, and I've heard of the Crown Court. Is there a difference?
So magistrates' courts and Crown courts, they're both criminal courts. Broadly speaking, magistrates' courts, they deal with less serious crimes. So things like minor shoplifting offences, like road traffic kind of offences.
Like speeding and things?
Yeah. And then the Crown Court is what we call a higher criminal court, and that deals with more serious cases. So it could be kind of serious assaults, like grievous bodily harm and things like that. It could be sexual offences, right the way up to murder and things like that. So they're the main differences between the two courts. A big difference is that in the Crown Court you get jury trials, which is probably what people are used to seeing on TV, where there's a jury as well as the judge. In the Magistrates Court you've got a panel of magistrates dealing with the case. There's no jury in the Magistrates Court.
If I lose my case, I guess the big question is, did my lawyer do a bad job?
Sometimes yes, but often no. So the way I would explain it is, the best lawyer in the world could lose a case that was just a very weak case, and the worst lawyer in the world could win a case that was just an extremely strong case. And you should always remember that. So the way the law needed to be applied to your case, your lawyer doesn't control the law, that's set by Parliament. So the way your law was applied to the case, and the strengths of your case against the strengths of the case of the other side just meant that your case lost. That's what should happen. Sometimes people do lose their case because their lawyer didn't do the best job or didn't do a good job, and I guess the potential signs of that are things like the lawyer didn't prepare the case properly, the lawyer made an obvious mistake in the court hearing or the trial, but it's definitely not necessarily the case that because you lost, your lawyer did a bad job.
Can I change my legal advisor?
You instruct a lawyer to represent you in court, so you can, if you're not happy with your lawyer for whatever reason, or your relationship with your lawyer, then you can uninstruct them and then seek new legal representation. Yeah.
And you can do that if you think they're doing a bad job?
Yeah. I would say it's worth having a conversation with them about, what your concerns are before you just kind of jump to the decision that they're not doing a good job. Because let's say something's been delayed and you think they're doing a bad job because of the delay. If you actually have the conversation with them, they might be able to explain, I wasn't in control of this delay, it was something to do with the other side, or it was something to do with the court process, which can be painfully slow at times because of how much pressure the courts are under and all of the procedures that courts need to follow.
And if you lose your case and you think there might have been something that was missed, or you don't agree with the decision, is there anything you can do about it?
There's something called a right to appeal. It varies depending on what area of law you're in and what court you're in. So if you do have a lawyer, then I would ask them, if you've lost your case and you want to know what your next steps might be, ask your lawyer to explain, do I have a right of appeal, and what are the rules and procedures to make that appeal. If you don't have a lawyer, you should be able to find information online on particularly on gov.uk. They should have information about how to appeal a criminal conviction or a criminal sentence, for example, and the same for the process for appealing in whether it's the family court or the other civil courts, or tribunals that deal with things like employment law. There'll be different rules of appeal for each area and each court.
Right. Ben Burns, thanks for your time. It's been really interesting talking to you about the court process.